Hey, welcome back, everybody. Law and Legitimacy. We're, once again, we are trapped in the cycle of time. It's Monday. We're beginning another week. The steep climb up the hill to the weekend, and then the rapid descent on Sunday night back into the pits of hell on Monday morning. Day 75. Day 75 this morning of United States versus Joseph Biggs et al., also known as the Proud Boys. And today could be the beginning of the end. We're scheduled to begin closing arguments promptly at 9 this morning. The government will open. It refuses to tell us who among them is going to give the opening statement. I talked to them Saturday and I said, well, what's the big mystery? Well, we haven't really decided. I said, of course you have. You've asked the judge for 2.5 hours for your opening statement. That suggests that one of you has gone through it and concluded, that's about how much time it'll take me to say everything that needs saying. So, well, it takes out some of the fun out of it if we let you know. And I said, one thing I will not be sorry to leave behind in this sorry mess of a case is this perpetual game of spy versus spy, cloak and dagger stuff. I guess if you're with the United States government, one of your few thrills is the ability to sort of keep a secret until you disclose it all to some 21-year-old Army technician and he publishes it on his feel-good gamer chat and it ends up on the front pages of the Washington Post and the New York Times. But I digress. So closing arguments will begin today.
Allegedly.
They will likely take place again tomorrow. And either at the end of the day tomorrow or early Wednesday, the jury will finally get the case. And, I'd like to think we'll get a verdict this week. But after, 4 months of proceedings and 10 counts and 5 defendants, there are 50 decisions to make, with lesser included offenses even more potentially. So I don't know how long the jury will be out. In the Oath Keepers case, the first of the major criminal seditious conspiracy trials, to take place incident to January 6th, the jury was out 8 or so days. I'm hoping that doesn't happen here. I'm eager to get home. Can't say I'm really eager to get back to work. It's been an interesting experience, fun sort of to get to know a new city, and the luxury that trial lawyers know, that is the ability to focus on one case as opposed to being pulled in 500 different directions simultaneously all day, which is what transactional lawyers or office-bound trial lawyers know of as reality, will soon descend back on me. So it's been real, it's been nice, it hasn't been real nice. Stay tuned for closing arguments today, but maybe you saw the 60 Minutes piece last night. The shadowy figure of Ray Epps was made the centerpiece of it. Ray Epps is the man in the red hat and a tan jacket, if you've watched J6 films, who was encouraging the crowd along the night before January 5th and was right at the front lines of a lot of the
most famous guy that does not get any attention, it seems, from the Justice Department.
No, and so, how is it that he could be right next to co-conspirators and not get charged? An entire conspiracy theory genre has developed around Ray Epps. And you'll remember Senator Ted Cruz once asking a Justice Department official, well, who is Ray Epps? And the Justice Department said, we can neither confirm nor deny that we know about Ray Epps, which is their locution for refusing to comment on anything having to do with confidential human sources. But last night, 60 Minutes does a piece on Ray. And of course, Ray is claiming his life has been threatened. He's the target of vicious rumors among conspiracy theorists. And CBS helpfully says, well, Epps wasn't responsible. Just the January 6th committee, the House committee, said there was evidence the Proud Boys were. And now I've got to walk into a courtroom today filled with people who are predisposed to believe in conspiracy theories and do my best Alfred E. Newman impersonation. What, me worry? It's just a coincidence that CBS published that on the eve of the jury going out. And we all know that as a matter of law, a properly instructed jury is presumed to follow the law. And the judge has warned them to avoid publicity. So I'm sure they didn't see anything. Let's begin, counsel. There'll be some pushback and some bitching and moaning in court today, and all to no good end, I suspect. And that's assuming that jurors don't report another problem as among themselves. We've managed to hold on to 15 of the 16 people that we selected back in early January. We need to hold on to just 12 through a verdict to bring this case to conclusion. Let's see if it happens. Alvin dropped his challenge to Jim Jordan and the House committees subpoena of Mr. Pomerantz. I can't remember his first name. Is it Mark?
Yeah, Mark Pomerantz.
Mark Pomerantz, who wrote a book on his work with the Manhattan District Attorney's Office in its investigation of Donald Trump. And I want to chest thump and say, as predicted, because there was no there there. This was a classic sort of federalism issue. Jim Jordan and Congress does not have police power over Manhattan, but it does have the power of the purse string. And to the degree that the Manhattan District Attorney's Office receives federal funds, Congress has a right to know how they're spending them. And so Jordan has his political motivations for wanting to know why Bragg pursued Trump at this time and in this way. And his justification, his nose under the jurisdictional tent flap, as it were, is federal funding. And so Bragg filed a lawsuit that sounded like a press release for the Democratic National Committee, trying to block Pomerantz's subpoena. A federal judge said no. We told you the federal judge would say no. Congressional subpoenas are largely self-governing, as it were. In other words, the Congress has the ability to subpoena anyone it likes under its legislative power. A person can challenge the scope of the investigation and say it's unrelated to Congress's legitimate oversight function. If that fails, and it was always going to fail given the federal funding here, there's really not much a court can do. It can't limit the subpoena. It can't quash the subpoena. Now, Pomerantz could choose to ignore the subpoena, in which case he might face the Tim Bannon treatment and be charged with criminal contempt. Then the Justice Department would have to be persuaded that that was a charge worth pursuing. They could decide to do it or not do it. Congress could also arguably, send its sergeant at arms, to try to take Mr. Pomerantz into custody. I'm not sure that the sergeant at arms has that authority or that power. But when one agency of government subpoenas, or when one branch of government takes action with respect to another branch of government, the fur usually flies. And in the federalism context, this is how it broke. So Bragg was right to withdraw the appeal to the Second Circuit, and it's time for Pomerantz to come and talk to Jordan. Whether he tries to claim some sort of privilege, that is largely a failing move. We talked about this at length when we talked about Alex Jones and his presentation to the January 6th committee. The only privilege that you can really claim is a constitutional privilege against self-incrimination. You can't really claim the attorney-client privilege in a congressional committee because the attorney-client privilege governs the courts, and Congress has already signaled it doesn't care about that privilege, or even some sort of deliberative privilege within Bragg's office. So Pomerantz will testify in May. We will see, what comes of that. I suspect Jordan will be wondering about the jurisdictional basis of the claims against Trump, whether, and Pomerantz in his book, I think, already told us what his testimony will be. It's an open question whether New York state law will permit the prosecution on a felony basis of Trump for altering business records to cover up evidence of another crime, that other crime being presumably election-related offenses involving his payment of hush money to Stormy Daniels. If I were on the Manhattan or the New York Appellate Court, I would let the case proceed. I think the crime is altering records, the state of mind that accompanies it, the motive. It doesn't have to be violation of a New York state law being the reason that you alter records. It could easily be a federal law. So we'll see. All that will play out in real time.
Some of the procedural background is interesting, right? So we know that the grand jury handed down an indictment of Trump, and then you read Mark Pomerantz's book over the following weekend. We talked about that book on Monday, and then Pomerantz was in the news the next Tuesday on this specific issue, right? Whether he was going to be relevant, because I think that was going to be something that the House Intelligence Committee wanted to talk about. There was going to be scrutiny on this case against Trump, regardless of what was going on. And then it was Alvin Bragg, DA Bragg, that filed a lawsuit against Jim Jordan in the House Judiciary Committee to stop the intelligence gathering or the appearance before Congress. The judge that issued the ruling saying that it could go forward was a Trump-appointed judge, and the Second Circuit is the one that did some sort of, I don't want to call it an administrative stay because I think that gives too much credit to some sort of substantive ruling, but they did some sort of administrative stop, a momentary pause to give the parties time to do something or another without giving effect to some sort of analysis of the substantive merits of the underlying case. And that was when this settlement occurred. Now, I put this on the screen.
Yeah, this is bullshit. This is fat Alvin, looking in the mirror and saying, "What a great lawyer am I." Our successful stay of this subpoena blocked the immediate deposition, and it afforded us the time necessary to coordinate with the House Judiciary Committee. Blah 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 blah. I mean, here's how it works when you get a subpoena from Congress. Somebody reaches out, you're told that you got to appear, and then you negotiate the appearance date, and you negotiate the various issues. This is Bragg face saving. He filed a dud of a lawsuit. He lost. He should have lost. He took an appeal. He withdrew the appeal because he knew it was going to lose it. And he's saying, what a brilliant strategist am I. I lost, but I bought myself an extra 2 or 3 weeks to talk to Congress. He always had those 2 weeks. So I don't want to hear it, Bragg. I mean, I don't want to hear your braggadocio, Mr. Bragg. You got nothing to brag about.
Well, but I guess that was my thing after that was, was there some sort of incentive to go ahead and settle this to avoid this going very quickly to the Supreme Court?
There was no there. I mean, I think Alvin has managed to blow fumes into a corpse and say, look, it lives, I mean, the lawsuit was dead on arrival. And it was the receipt of federal funds by the Manhattan District's Attorney's Office gave Congress oversight authority to talk about how those funds were used. Period. That's the beginning and the end of the discussion. So the claim that somehow Alvin needed to buy time with this lawsuit so that they could do what exactly? Prepare for the loss in the Second Circuit. This is face saving at its worst. And so, Bragg didn't have a leg to stand on with the lawsuit. Pomerantz is going to have to appear in front of the committee. There may be things that he says he doesn't want to talk about. The committee may honor those things. It's really up to the committee. But what Alvin's not going to be able to do is run to a court and say, I don't want to answer Congress's questions about my investigation. There are no privileges that Congress is bound or required to honor with respect to an oversight committee. You look at the Enron investigation, for example, there were lawyers who were claiming in front of, when Congress did some oversight work there that led to the passage of the Sarbanes-Oxley bill. There were lawyers who didn't want to testify, claiming attorney-client privilege, one of the most important privileges of law. And the committee said, tough beans. The attorney-client privilege applies in a court. This isn't a court. You can't go to a court to quash because we want to ask questions because the court has no authority over us. This is similar to the drama that's playing out right now with Clarence Thomas and the Senate's desire, Dick Durbin's desire to have Chief Justice Roberts come in and answer questions about the ethics of the members of the Supreme Court or ethics rules. Roberts isn't obliged to come in and testify in response to a subpoena. Who's going to enforce the subpoena against the Chief Justice should Dick Durbin issue one? At some points, given the separation of powers, there are yawning gaps in the record. There are times where you just aren't going to be able to compel one branch of government to do what the other one wants, and we're seeing that here. But you've got a bill on a piece of legislation on the screen. What's this, Mike?
This is the Alvin Act. If you can believe that. So you were talking about how there was no there, the federal oversight of funds allocated to state stuff, which would give Congress the oversight power. This bill was filed on April 12th, and it's entitled the Alvin Act, but it's to prohibit federal funds from being awarded or otherwise made available to the Manhattan District's Attorney's Office. So this is one of the many bills before Congress, but this one in particular is what I think drew a red flag for everybody involved, because a lot of the people on the right that were very critical of this, in and among the other aspects of this being a political prosecution or what have you, the one thing that stuck is, okay, we had the Federal Elections Commission and we had federal prosecutors look at the facts attendant to this exact same state case and declined to prosecute, declined to bring any federal charges pursuant to any election issues or issues related to what could ostensibly be the same thing with respect to falsification of business records norm. But what's curious is to what degree the state district attorney's office, Manhattan's district attorney's office, used the allocated federal funds in building this prosecution against Donald Trump. And that's something that I'm starting to see, Norm, across the country with other attorneys that do any sort of blogging or podcasting, live streaming. I'm starting to hear rumblings from the criminal defense bar that at least in one case, they're having trouble resolving, what their friends and family think about this. They really want to get Trump. They're just sort of against Trump, at the outset. But contrasting that against the method by which the state district attorney here is actually using resources to go after someone like President Donald Trump. And then this bill sort of gives an insight into that, is that if there were some sort of audit as to where federal funds went in the prosecution of Donald Trump, that may be more damaging to Alvin Bragg and his office than any sort of, I guess, prospect of a return on investment, so to speak, in the prosecution of Donald Trump. Because we talked about it before. There are 3 other pending matters going on that are going to involve Donald Trump. And I think that perhaps the move to settle this and to allow Pomerantz to go before Congress and to pretend or to feign some sort of, victory is perhaps to wait and see if something out of Georgia will start drowning out the noise that's being generated in New York.
Maybe. I think it's much ado about nothing. I think that Alvin dove for a headline. He's got his case. Whether the appellate court permits it to go forward is an open question. I just think this was and tension between branches of government or between state and federal governments are as old as the republic, and they're supposed to exist. If you want to live in a seamless web of a governing society, go live in China. Where, if you don't like what the Central Committee's doing, they'll execute you and make you pay for the bullet, or your state pay for the bullet they used to kill you. I mean, tension is good in federalism, where we don't have a system of government that is designed to operate efficiently. There's supposed to be friction, and this is the sort of friction you're supposed to see. So the system is working. Everybody take a deep breath. Let's move on to the next thing. And I guess while we're talking about Trump, Jean Carroll's suit against Trump begins this week, and whether he attends the trial is, I guess, an open question. He's settled on Joey Tacopino as his lawyer in New York. Tacopino, you saw at counsel table in the Bragg matter relating to the business records. Tacopino has emerged as lead counsel apparently in the Jean Carroll thing, and there's a dispute about whether Trump will be forced to attend court. Jury selection begins this week. Miss Carroll, you'll realize, is a former reporter who claims that some 30 years ago Trump sexually assaulted her after they ran into one another at a department store, went back to a hotel room, and one thing led to another. She is a beneficiary of new legal rules that permit alleged victims of sexual assault to bring actions long after the event. Statutes of limitations have been suspended, presumably to vindicate the rights or the interest of those who emerged in the Me Too movement. I find this manipulation of statute of limitations inherently offensive. I mean, how are you supposed to launch an alibi offense when you or any other defense to an activity that occurred 25, 30 years ago, if it occurred at all? But balancing the social equities, we've decided that, she who complains must be heard. And so Ms. Carroll will have her day in court. Trump is not...
I saw a little bit on that last week, and I think the judge was basically denying any alleged issues that Tacopino was trying to raise with respect to, interruption of the court activities and stuff like that. So it seems like right now Trump is going to have to be there at some point.
Well, no, what Tacopino tried to say is he wanted the jury told that Trump was absent, but he was absent because he was concerned about the logistical difficulties that it would impose upon the court system for him to appear. And the judge kind of said, bullshit. I mean, and he should have. I mean, Joe Tacopino is an aggressive lawyer, and I like aggressive. And he's smarter than the average bear, which means his IQ is above 100. But nobody's ever accused him of being too smart for his own good or his client's own good. So he's chest thumping, and he's trying to make the best case for the Donald, and Donald wants a Roy Cohn, and Cohn was the sort of vicious genius. Tacopino is just sort of a middling thug. But Tacopino tried to strong arm the judge and say, hey, the Donald can't be here, and it's because he cares about logistics. And the judge said, you had months to think about it. He appeared in Manhattan. You can't. Neither side can comment on Trump's absence in the civil trial. Now, the other side, meaning the plaintiff, they can subpoena him to his own trial. They can also use his deposition testimony at trial, and they have deposition testimony and play that. If Tacopino wants to call him, he can. At the end of the case, one side or the other may try to get an adverse witness instruction from the judge, and we'll have to see how that plays out. But I suspect this trial will be a week or two of drama. Hard to know what the result will be. I suspect it's just hard to know what the results will be. I've never paid much attention to the case. I know she's also sued Mr. Trump for defamation. That's a separate proceeding that'll take place on another occasion. But the Donald is getting what he wants, and that is nonstop press coverage. And here we are talking about him some 22 minutes into our presentation. So banned books are in the news again this week. The American Library Association released just this week the list of the most banned books in America.
I think they're set to do that today.
Okay, I misunderstood. I read the story and thought it had already occurred. Is this banned book week? If it is, it's a good occasion to read a banned book. As a bookstore owner, my wife and I own a shop called Whitlock Farm Booksellers in Connecticut. Reading is fundamental in my view, and books are friends, better friends than people, in my view. Banned books are lightning rods that reflect tension in our society. What's being banned and why people are seeking to ban us tells us a lot about ourselves. According to the American Library Association, the number of assaults, the number of attacks on books in libraries has increased 6 or 7-fold in the last year or so.
The assaults.
Well, hey, what can I tell you? A book, and right now, most of the book banning is part of our culture wars. The old favorites, Joseph Heller's Catch-22 and whatnot, those are banned perpetually. But now these are titles that relate to LGBTQ stuff. And so parents are saying they don't want on the shelves literature about, Johnny's homosexual experience or Jane's two moms or whatnot. And they don't think children should be exposed to this sort of material, and the book should be banned. And, my view is you can pick your sides in the culture wars. I'm more inclined to take the view that traditional values are worth defending, but I don't think books need to be banned or that ideas should be banned. If parents want to have some control over what their children are reading, then they should control what their children are reading. But the idea that you should take a book off the shelf and make the ideas and the points of view inaccessible to those who want to see them is offensive to me. So we see, Mike, you've got highlighted on the page here, according to the American Library Association, between 2020 and 2022, the number of individual titles banned in libraries across the United States spiked from 223 to 2,571. In fact, there was a story, I can't recall in which press last week, about a local Texas library that was going to close, that debated closing rather than comply with a court order that certain books be left on the shelf. You want to talk about closing of the American mind. You want to talk about the dangers of woke orthodoxy and so forth. Closing libraries is a tremendous mistake. And my view is, if you find a book that offends you, the question should be not why is the library covering it, but why does it offend you? And who should you be talking about what offends you with respect to that book? You don't want a book about homosexual children or gay lifestyle or whatnot on the library shelf. Talk to your librarian. Ask the librarian why they've put that book on the shelf. Find somebody who's reading it. Ask them why they're reading it. And then tell them your reasons for believing that book is bad for them, or your point of view that suggests that the public ought not to finance publication of that book. I will never be a book banner. Ray Fahrenheit 451, was it Ray Bradbury? I can't recall the author's name. Is a chilling story. It's a society where books were burned because the ideas that they expressed were threatening to the orthodoxy. Ideas are our lives, aren't they? We are what we think. We are our history. Don't take books off the shelf because they offend you. Read them because they challenge you.
Two things here, Norm. The first thing is just acknowledging the timeline that's being referenced here in the statistic. So, what was going on between 2020 and 2022? Well, we know widespread school closures all across the country and a pivot to sort of a virtual classroom. And we've talked before in other contexts about parents being able to finally
that's a really good point. See what's going on in the classrooms.
Finally having insight as to not only what children were reading, but how the material was being presented and what was being asked of students in response to certain material. I think that there's a lot to be said. So if you look at this statistic in a flat manner, my second point, I'll just roll into this first one. My counterpoint to that 1,100% increase in the number of individual titles banned between that timeline, I would like to also know how many of those titles that are being banned existed prior to 2020 or existed prior to several years before that happened. Because what we've also seen is that, some of these large chain bookstores like Barnes and Noble and otherwise have begun positioning these books that are inherently controversial from a cultural perspective in the front of their bookstores. They are putting all of these things together, and they are lumping these LGBTQIA plus titles alongside certain things that had to do with Kamala Harris or Michelle Obama or Barack Obama or these other politically left-leaning leaders, and they're pushing everything into this one sort of progressive left box. And we must, if we're going to be intellectually honest about the banning of books, we have to acknowledge that there are legitimate concerns of parents all over the country. And I think that we have a unique window to refer to say, if this were 2015 to 2018, I would say, yeah, what is going on where we have an 1,100% increase in the number of titles being banned? But from 2020 to 2022, I'm not so pushed back by that number, because I think it's a natural corollary to the fact that parents finally had some transparency and they wanted to take accountability over the way the instruction was going in their students' classrooms. And I guess it only really goes for those that were actively in school, quote unquote, in a virtual capacity, because we also know that many of the students that lacked internet access weren't really exposed to this anyway. So wanted to bring those two things up.
Well, they're good points, and to the degree that book banning reflects the so-called culture wars in our society, I'd like to find a way to engage in that warfare without burning the material that we're fighting over. So I'm looking at some of the titles banned. Juno Dawson's "This Book Is Gay," Jonathan Evanson's "Lawn Boy." And these are probably books that weren't even on the shelves or weren't going to be on the shelves prior to the last few years. And as you point out, the effort to put up a sort of DEI reading list in every schoolroom does reflect the narrative that somehow expressive individualism is the be all and end all.
And this falls in neatly with the libs of TikTok phenomenon, right? Where libs of TikTok began just publishing these TikTok, these video shorts where certain teachers were saying, I keep up this flag in my classroom. I teach students that this, when a student asks me this, I tell them, and just admitting to being invasively involved in directing some of these students' conceptions of their identity and sexuality, or talking about, certain non-traditional things in very young demographics. So context matters a tremendous amount here, as it does in normal circumstances, but context in this respect matters a tremendous amount. So we'll see what the titles are that were the most banned. I'll see if I can't keep a tab on that today, Norm, and we can revisit this. But I'm not moved.
And not just what was banned, but where. So I mean, I'm aware that one library that had received complaints about the Bible because the Bible contained, homophobic content and violence and so forth. And I thought that was a bridge too far. But as I think of any book banning, but let's do keep an eye on it and try to engage folks on the cultural wars.
We will.
So we've talked our way or dribbled our way through a half an hour. And so I'm going to end this, as I've ended so many half an hours recently, by saying objection.
Overruled, counselor. And everybody knows that you're going to be live at Mohegan Sun on May 18th. Your re-debut of your stand-up comic career will begin anew, and we're hoping that you can get out of closing arguments by tomorrow afternoon and head back to Connecticut, or maybe perhaps the Northeast Kingdom, for some well-earned reprieve.
I need it. All right, folks, thanks for listening in. Spread the word. We're back. We're here. Tell us what you want us to talk about. There's lots going on in the world. Some days it's kind of overwhelming. Today, I think, was one of them.
It is, but you can find us on Apple Podcasts, Spotify, Google Play, Overcast, etc. Please consider a membership and/or subscription on Locals. Definitely give us a thumbs up on this video, and we'll be live tomorrow morning at 7:45 to continue on. Norm, we'll see you tomorrow.
Ciao.
Bye.